a really important webinar today covering when, why, and how to use securitization audits. And as you all may know, they've been around for a while now, and there's been tremendous success with them. And there's been, depending on the strategy used, great success, but also lots of failures and wasted money when the correct strategy is not used. So today we have an expert panelist named Michael Wood, who will be going over and speaking about the securitization audit industry as a whole. And we want to encourage everyone's questions today. So please type in your questions in the chat section located in the control panel, and it should be on the right-hand side, and we'll answer them live for you guys as well. So moving along. So we're going to cover what TLP Advantage is and, the concept of securitization audits. A little introduction in case you guys haven't spoken with me before. I'm the founder and CEO of the Loan Post, which has been around since 2008. It's the most widely used CRM system for loss mitigation. We created TLP Advantage within about a year and a half ago to form a network of loss mitigation firms and professionals that can help each other for all the various services and products like loan audit processing, litigation, audits, and real estate acquisition as well on the short sale side. We've seen the results of Michael Wood's audits recently, and his detailed level of attention, we learned firsthand from a handful of clients doing loss mitigation. So today, we're proud to introduce Michael Wood as our exclusive securitization audit provider. And we know that his services and training ability will help many of you learn how to leverage these audits for your client's benefit, and that's what we're going to cover today. So, Michael, go ahead and take it away and give a little background on who you are and how you've been working with us.
Oh, hi. Thank you, Chris. Thank you very much. This is Michael Wood. I hope you all can hear me. I'm speaking to you from the state of Washington. I'm a veteran of the mortgage industry for over 20 years, own my own company, and very active in compliance and documents, drawing, et cetera, for all my clients. And in 2008, I made the switch from doing originations to helping people overcome adverse situations with their lenders. And since 2010, I've been focusing on doing forensic examinations and securitization examinations and uncovering the chain of title and in general looking for issues that in violations that would give homeowners a little bit of a leg up in their negotiations with their lenders. And I've been doing these exams for going on 5 years now, so I've got quite a bit of experience and have seen a lot of different situations, and I'm happy to be here to talk to everybody today. We can go to the next screen. So let's start with the timeline and just a quick little history on mortgage securitization. In 1998, the federal government disbanded they signed the Gramm-Leach-Bliley Act in place, which took out all the teeth in the Glass-Steagall Act, which basically allowed investment banks and commercial banks, by commercial banks I mean where mom and pop keep their savings accounts, to merge and become one again. And this created the situation where Wall Street could come in and figure out new ways to recycle money and to work within the lending system to securitize these loans and sell the securitized products to end investors after it was all done. And this put Wall Street and Goldman to work kind of reinventing mortgage funding. Before the securitization, a lot of the lenders would actually kind of turn their clients upside down and shake their pockets out to see if they could repay a 30-year loan. Well, with the advent of securitization, most of the banks and most of the lenders aren't holding on to the paper for much more than 30 to 60 days before they sell it off and it gets pooled, and those pools turned into certificates and bonds, and they get sold to end investors. And that's kind of the history of how the securitization started. A lot of people say, well, is securitization legal? Yes, it is, and what I look for are violations in the securitization process. So let's continue on. One of the things that happened about the same time as the disbanding of the Glass-Steagall Act was the formation of MERS. MERS was formed by major banks as a registry for their mortgages. In the securitization process, loans are being sold typically 3 to 4 times to get them from the closing table and into the trust. And it's required in most states that they assign different ownership at each step of the way. So they created a system called MERS, which is a Mortgage Electronic Registration System, thinking that that would be a record-keeping vehicle that would allow them to bypass the costly and burdensome situation of having to actually physically record these things. And it actually ended up taking billions of dollars out of the county coffers, and a lot of counties are now banding together to sue to get some of this money back. But if you figure 64 million loans in the MERS registry, which is kind of the agreed upon number that they have, and you figure 3 assignments per loan at about $40 per assignment, then you can see how that would add up to billions of dollars pretty quickly. A couple of things about MERS. MERS is an institution that holds, it's a registry. It doesn't hold beneficial title. I work in the state of Washington, and I do these securitization audits nationwide, and I know that in the state of Washington, MERS has been, their status as beneficiary has been challenged at the Supreme Court level, and they've been found not to have status as a beneficiary. I know each state is a little bit different, but basically the same thing holds true. They act as a registry for loans, and they don't really have any benefit by way of collecting money. They're not a beneficiary. They're simply an informational repository. They're required by their bylaws to keep records of every transfer of ownership, and those records are held in something called the MERS Milestone Report, which is not a report that's available to the public, but it's a report that is available to their members, and they make it available upon discovery in a court case in that type of situation. And that gives a detailed history of each loan in their system. So let's continue on. So when we're looking at securitization audits, a lot of people ask me, what's contained in a securitization audit? What's covered? And first thing we look at is the note. Where did that note go? Was it secured? Did it go into an SEC REMIC trust? Is it in the Fannie Mae system, in Freddie Mac, or in Ginnie Mae? Most of the FHA and VA loans go into the Ginnie Mae system, and Fannie and Freddie cover conventional loans, and the SEC REMIC trusts are formed for the vast majority of loans. And we're going to look to uncover the path of that note and find out, did it go, how many entities did it go through? Typically, we're going to see a note, if it's securitized, it's going to go from the closing table, which is the lender. It'll go to an originator, and it can be serviced by that originator or another entity. And the typical path is from the lender to the originator to the sponsor seller, and then to the depositor, and then to the trustee for the trust. And at each step of that path, by the regulations and by the rules and regulations of the pooling and servicing agreements, those are all separate and distinct transactions, and the loan is owned free and clear at each step of that way. And if it's not in compliance with the pooling and servicing agreement. And the banks and trusts have been, as I'm sure everybody knows, over the last several years, have been really desperate to, in the foreclosures, to come up with documentation showing, who clearly who owns that loan. And one of the things that they come up with is assignments, substitutions of trustee, and they're filing these things really without having any standing to do so. So continuing on, what I do is I look at the recorded documents, and I'll look for some telltale signals. I look at lenders. I'll look at the date on the loan, and a lot of these things are keys to telling me, was that loan securitized? Is there the presence of MERS? And once I get into the recorded documents at the county level, things such as assignments, substitutions of trustee, notices of trustee sale, I'm going to look and make sure all the signatures are valid. Was it signed by a known robo-signer? Was the document itself prepared at a document mill? These are all indicators that will tell us whether there's a possibility of a forged signature on that document, whether there's a possibility of somebody signing that without verifying the facts of the document, and it'll also let us know whether that document's in compliance with the pooling and servicing agreement. And we're going to look at the dates of the assignments, we're going to look at the substitutions of trustees, we're going to look at the notices of trustee sale, and I've seen many cases where we've got forged signatures on all three of those types of documents. And when you have that, you're going to be dealing with breaks in the chain of title, you're going to be dealing with standing issues, and it's going to give the homeowner a lot more standing in their negotiations or dealings with the lender. Let's continue on to the next screen.
Did you want to look at one of the audits, Michael?
We can do that. Yeah, let's go through this screen, and then we'll get you to open up a sample audit. When we talk about robo-signers, I just want to make sure that everybody knows. Oh, there we go. Okay, let's start at the top of that. This is a recent securitization exam that was done for a client in the state of Washington. And the first thing you're going to see is a table of contents that'll kind of outline the steps and what's contained within the report. And typically, we would go to, there's a number of screens, a number of pages in here that deal with really the meat of the matter. We establish the facts up front. We look at the statistics of the transaction, the statistics of the loan. We look at we do some research on Fannie Mae, Freddie Mac, MERS, and then we're going to look at, let's go to page 5, shall we? Okay, this is a general chart that we include that deals with, in this case, the securitization participants. We've got, I don't know if everybody can read this, but we've got Lehman Brothers Bank as the lender on this particular case. The sponsor is Lehman Brothers Holdings, Inc. The depositor is Structured Asset Securities Corporation, and it went into the Lehman Excess Trust Series 2006-8, okay? And at each of those stages, the originator, the sponsor, the depositor, and the issuing entity, those are all separate and separate transactions, and the loan has to be transferred encumbrance-free at each step of the way. And they do that to make themselves bankruptcy remote. So let's continue on down to page 30. We're looking here at a screen showing results of the research that we've done. Okay, if you can back that up one screen. Okay, this is the third section of the report, the foreclosure analysis, and we're going to take a look at who the parties are. And on the left side of the chart, you're going to see the recorded chain of mortgage possession, and on the right side, you're going to see the chain of note possession. Okay, and we verify these through different databases, such as the SEC Edgar system, ABSNet Lutan, Bloomberg screens. We'll verify however we need to get an accurate depiction of who owns the loan and where that note went. And we can see that in this case, on the right side, the chain of note possession, the note was signed on April 19th of 2006. Lehman Brothers Bank was the lender. And in May 31, which is the closing date of the trust, it was placed into the Lehman Excess Trust. Okay. On the chain of mortgage, we can see that on April 19th it was recorded in King County. And on May 23rd of 2012, 6 years later, there's a corporate assignment of deed of trust from MERS' nominee to Aurora Bank. And this is done 6 years after the closing date of the trust. So continuing on down, we can kind of see how that path went. They've recorded an appointment of successor trustee, and then in 2012 there was another assignment of deed of trust from Aurora Bank to NationStar Mortgage, and this was done by NationStar for Aurora Bank. They were claiming to have power attorney-in-fact status, and then they attempted to appoint a successor trustee as well. So let's continue on down. We'll continue this path. Kind of goes on to the next page. Okay, and then we've got NationStar appointing Cal Western as successor trustee. And there's a new, in 2014, there's a new corporate assignment of deed of trust from NationStar back to the 2006 Remick Trust. Okay, and this is just a little glimpse of a timeline. It gets discussed in more detail, obviously, down below. And then in February of 2015, there was a notice of trustee sale issued. So let's continue down, and we can take a look at what we do with the report summary down below here. We discussed the deed of trust, and we established when it was signed, the loan amount, and who the parties are. And we continue down and discuss the note securitization. And then on the corporate assignment of deed of trust, we're going to take a close look at that and see who signed that. We're going to see when it was signed, et cetera, et cetera. And in this one, we're calling out that this one was signed by a party that shouldn't have had the ability to sign that, and it was signed 6 years after the note was placed into the Lehman Excess Trust. So we've got a situation here where a loan is attempting to be placed into a trust 6 years after it was done. And we note down below, Aurora Bank was the original lender on the loan, and they're trying to, in this case, transfer the loan back to the original lender 6 years after the funding and likely securitization. So let's take a look a little bit farther down. Okay, and here we put in the actual documents that are being used, and we see who has signed that, and they've got a seal for mortgage electronic registration systems, and they're actually trying to assign this to an entity that already is in the transaction, which doesn't make sense at all. So let's continue down. And this one deals with the assignment of deed of trust in a little bit more detail. We're going to bring out the parties. We're going to bring out whether they had standing to actually do what they say they could do. Okay, and we look down. We see that NationStar Mortgage makes the claim on this assignment that it's attorney-in-fact for Aurora Bank FSB. And in order to make that claim, they have to reference a power of attorney. They have to actually show a recording that they recorded that power of attorney, and without that, that's hearsay. So the law looks at that, as I'm sure everybody knows, as a preventive step to prevent people from stealing properties. NationStar Mortgage is claiming that they have attorney-in-fact status when they haven't referenced anything that proves that. Okay, so that's one of the first issues that we raise, and we also note that the document attempts to assign all beneficial interest to NationStar, and then we request that they produce that original note and then show that they have beneficial interest by way of the notarized bill of sale, note endorsements, and verifiable proof of funds in support of their claim of beneficial interest. Let's continue down. And then we'll actually show that document and show that NationStar was attempting to assign as attorney-in-fact, and we can see on the document itself there's nothing referencing anything that gives them that standing as attorney-in-fact. Okay, let's go ahead and continue down. And in this case, we've got successive assignments in 2014 where this loan was attempted to, they're duplicate assignments, and the signatories are different, but we've got two attempts to assign it back to the original trust. So what I do is I just take each of the defects in these and I'll kind of outline it. And we found that and these are sort of accepted hallmarks of robo-signing and defective documents. Number one, the name of the signing party is stamped on the document in block letters. Number two, the document appears to be standard form with fill in the blanks for the names of the signers. The assignment relies for its legal effect on the defective assignment previously discussed. And the mortgage and deed of trust is assigned months and sometimes years after the date of the origination. And continuing down, we'll take a look at some more of the violations here. And we've got Eric Rittmiller signing the assignment as the Assistant Secretary of NationStar Mortgage. And we noted on him that he's executed a number of documents on behalf of NationStar, and we've found different signatures that appear to be different. So we're going to come down and we're going to look at the assignment that has his signature on it, and that's the subject assignment that we're dealing with. Okay, and you can see that it's basically just a little squiggle, not even really a signature. It's not even really initials. It's just like a little W. And then I have a database of signers and signatures that I can pull from actual recorded documents. And we see that Eric Rittmiller has a different signature on the one down below, taken from Saline County in Alaska. And then going down even further, we just note that there's discrepancies in the signatures, and we recommend the use of a qualified handwriting expert, because it's important to know that the person signing the document is signing beneficial interest in the property, has the authority to do it, and actually was present at the signing and signed the document. So these are some of the main things that we see on a day-to-day basis. We look for robo-signers. We look for forged signatures. We'll scour all of the databases to find out, was the loan put into a trust? Was it securitized properly? Did it abide by the pooling and servicing agreements? Did it abide by the trust laws that were in effect in the state in which it was securitized? So that's kind of a good example of one of the reports that we've done. We go on here to analyze MERS, and we give a quick little discussion on MERS and their standing in the transaction. And we show that, they're showing NationStar Mortgage as the servicer in this case, and U.S. Bank as trustee as the stated investor. And when I see somebody mention like New York Bank and New York Mellon or U.S. Bank as trustee, that usually is a very strong indicator that they're a trustee for a trust. And if I haven't already uncovered the trust, I'll certainly redouble my efforts and go find that trust that they're representing as trustee. So let's continue on down. We'll actually go to the MERS servicer ID and pull the actual screenshots out that show what MERS is reporting. Okay, and then we'll finalize the report with some discussions on the securitization process, how it pertains to the loan. We'll incorporate the individual loan into the securitization discussion, and that will be followed by a discussion of MERS standing. And the reason we do this is not that we're trying to be attorneys, but we want to make sure that we give certain case law and certain arguments that have been made successfully by professionals around the country that will sort of accentuate the case for the homeowner. And we'll do that as sort of a final step of the securitization exam just to give you a little bit of extra ammo if you don't if you need it. And then we move down to the further down. We're going to go into the declaration and affidavit section, and that should be.
What page would that be?
Getting down to it on my screen, I believe we're going to be at page 48. Page 50, excuse me. And this is where we summarize everything that's in the exam. And I'll give my experience and how I'm trained and what I do, and a quick disclaimer that my observations, when I refer to case law, I'm not attempting to practice law, but I use certain case law and certain rules and regulations to uncover violations, and everybody who does what I do does the same thing. And continuing down, we'll look, I just mentioned the databases that I'm trained on, and the fact that the contents of the report are factual. And then I'll summarize, starting on item 5, I summarize what I've done in the research and summarize some of the findings that I found, and go on to summarize the securitization process and the violations as discussed in the report. And that'll be items 5, 6, 7, 8, 9, and 10. Okay, and item 11 deals with the foreclosure activity. And if needs be, I will give that a little bit of extra attention by way of calling out some of the defective assignments, some of the defective documents, and make sure that those are summarized once again for anybody reading these. And that's basically the nuts and bolts of the report and what we do. We will uncover actual violations. We have different criteria for looking into different databases. We look for loan level detail whenever it's there. And we look through county records to uncover clues, and we look through, a lot of folks do a QWR at the very beginning of the process, and we'll look at the results of those as well. But this next screen on robo-signers is more of a, everybody wonders how many there are. And there was, back in 2010, when I first started doing this, there was one of the mucky mucks at MERS was in front of a congressional hearing, and they asked him how many there were, and he said that there were 20,000 people that were signing documents for MERS back in 2010. And this is really a sizable army of people, and most of these are people that work at banks, work at servicers, and they may or may not know. In most cases, they don't know what they're signing. In a lot of cases, these robo-signers aren't even signing their own name to a document. They're just somebody that's employed, and they're signing somebody else's name, whoever's name is printed on the document. And this, back in 2010, this was a pretty sizable army that was creating foreclosure documents. Let's continue on. And this is a signature comparison page that I've taken from another of the reports that we've done. Another known robo-signer named Bud Kunyabi signed, the first signature was from the subject assignment. And you can see how that signature looks versus the middle signature and versus the bottom signature, which were all taken from recorded documents signed by the same person. And this is what we're finding over and over and over, that these documents are signed by people who are oftentimes in different parts of the country. They're never the same person, and it's hard to, it makes it impossible to know whether the person that signed it, that claims to have signed this, actually signed it. So this is one of the violations that we'll uncover, and the purpose of doing this is to highlight the amount of fraud that goes on in the process, and also to call into question whether the homeowner's assignment is even valid. Was it signed by a real person? Or was it signed by the person who he claims to be? So let's continue on here. This is a little diagram of the securitization process. I know that there's many such diagrams out there, and this one kind of tracks things between the homeowners at the top and the individual investors in the mortgage securities down at the bottom. And the homeowners get they deal with a loan broker on the right-hand side. The loan broker deals with a warehouse lender. The warehouse lender goes to Wall Street for the money market funds and puts those into play. The servicer and the trustee are collecting funds and paying off, putting money into the trust. The money is then being used to pay the investors, corporates, pension funds, insurance companies, and other individuals. So that's just a basic diagram of the securitization process. It's very complex, and there's money to be made at each step of the way. And what it has done, it serves to confuse and cloud the actual ownership of a note, and hence the need for securitization audits. If you want to find out, is the party that's foreclosing, is the party that I'm dealing with, do they have standing to deal, or they have power of enforcement? This will help to uncover all of that. Let's continue on. So basically, why would somebody want a securitization exam? In the past, up until a few years ago, lenders had preferred standing in any negotiation or adverse action with the borrowers. The lenders have been so heavily regulated in the country that the courts for years thought that they were so regulated they couldn't do anything wrong. And borrowers were assumed to be in the wrong right from the get-go. In the court system, it goes on sort of an honor and dishonor system, and borrowers were automatically assumed to be in a place of dishonor because it was assumed that the lenders could not do any wrong. And we've got a situation where we've got county recorded documents that have been trusted for 200 years that now we're finding that they can't be trusted. I've seen, like in Essex County, Massachusetts, they've done an audit of the complete county records there, and they described their county records as a crime scene because of the amount of robo-signing, the amount of forged signatures that they found, that they uncovered. So for years, the facts that the banks presented were assumed to be true, but we're finding out that through the hard efforts of many, many attorneys in the country who are working their tails off up against very, very difficult odds, we're finding in getting help from securitization exams and et cetera, et cetera. We're finding that that's no longer the case. Let's continue on. So we come to see that homeowners need equal standing, and that's what a securitization, that's the best thing that we can provide with an audit, is we can uncover violations committed by lenders and their agents, and we can present these in fact form, in the form of a report that a lender or a court can understand. And this gives the homeowners more equal standing in the transaction. And around the attorneys that I talk to and deal with on a day-to-day basis are letting me know that wrongful foreclosure is kind of the next big thing that's going to be coming up on the horizon. People who have been foreclosed on using false documents, using lack of standing, these are going to create a lot more court cases. And the way to find these things out is through the securitization exam process. Let's continue. So when we look at how to use an exam, some of the strategies that non-attorneys are using, and these folks are advocates, they're paralegals, they're homeowners acting on their own behalf. We would say to, number one, order a QWR and a securitization audit, get the facts, both from the lender side of things, that would be the QWR, and from your own research, which would be a securitization audit. And then you can leverage these audit findings during negotiations. If you're going for a loan mod, if you're going to mediate, and you're not getting treated correctly or fairly, you can actually start to apply a little bit of leverage through the use of the facts. And we've seen a lot of cases where modification results are enhanced by using report findings with, either the loss mitigation department or having it escalated to a managerial level. And settlements using these reports can include principal and rate reductions. And we just, I have a case that I worked on recently where a homeowner had a nice piece of property on a lake outside of Seattle. And he had about $2 million in equity, and his lender was coming after him. And I got involved about halfway through the process and did a report that raised a lot of doubt as to whether the lender claiming to have the original note actually did. And they did an examination on the note, proved that it was a forgery, and they've been in a situation now where the homeowner has had a $6,000 a month mortgage payment, and they've not made a payment in about 4 years, and it looks like they're going to settle this thing, and he's going to walk away with $1 million to $1.5 million in equity. And he was actually grasping for straws when we came in and did the report for him. So these are some of the examples that you can use to leverage time, leverage a result, whatever you need to do. Let's continue. So on the attorney side, as I'm sure some of the people on the call are well versed in strategies and how they're being used and how securitization audits are being used. You can get a paralegal to order a QWR and a securitization audit. One of the things we recommend is searching your local and federal case law and see how they're treating findings along the lines of chain of title, robo-signing, forged signatures, trust violations. And there are a lot of attorneys that will put somebody into bankruptcy, order a report, get the facts, show that the chain of title is clouded, and then use the bankruptcy trustee to force the lender to prove their claim. You can also use the audit to leverage a situation pre-litigation. A very common strategy with a lot of the attorneys that we work with is that they'll actually file a complaint and file a court case based on the facts presented in an audit, and then kind of back it down from there and use settle with a modification. And the nice thing about that is that they're dealing in facts, and the lenders has to decide whether they want to go to court or whether they want to settle, whether they want to do a modification. And as I'm sure you guys are finding out there, a lot of times they actually want to do that modification. So let's continue. And this, I alluded to it just a second ago, is that the lenders don't want successful cases against them. It creates a bad precedent. It opens them up to more expensive litigation. In a lot of cases, they're willing to settle and modify if you've got facts on your side. The settlements we've seen include principal and rate reductions. I had another case here in the state of Washington where we did a report and uncovered some violations, and they were in with a paralegal, and the paralegal was guiding them through the modification process. They entered into a mediation because they got a foreclosure notice, and they ended up settling with a modification that reduced their principal balance by $140,000. Their rate got reduced down to 2%, and they got a 40-year term. And that was after we put the securitization audit into the process, and they were able to use that as well. So the securitization audit is a very viable part and a very viable component of your negotiations and your actions in interacting with the lender for either a modification or a successful case. It plays a big role in a lot of the cases that have been found in favor of homeowners that people like to quote had securitization audits involved in them as well. Let's continue on. And this is important too. There are big differences in examinations. One thing you don't want in your exam is a lot of guesswork and a lot of hype. You don't want to have software audits done. Those were in the beginning stages, 2008, 2009. There were a lot of audits out there that were primarily software audits, had a lot of boilerplate language that really didn't apply to much. You want an exam that's done by somebody who has experience, who knows what to look for, and is taking the time to examine the situation by hand. Somebody who will go through the database, will bring out the facts, and will put them into a concise report. You want all the issues that are raised to be actual violations, and you want them written to have legal standing, meaning that you don't have a violation quoted that can't be backed up, can't be documented. Let's continue on. And this is really the advantages that we've worked out with Chris and TLP. Is the main advantages to using us is we're professional, we're quick, we offer a great turn time for everybody, our results are reliable, and the pricing is, Chris will get into that in just a few minutes, but the pricing is pretty incredible. So we have basically three choices for everybody, and we recommend a free pre-screen, and not a lot of people will offer you that. That's a basic look. You'll upload a few documents, a note, a deed of trust, and any assignments that you might have, or your QWR if you've got that, the QWR results. We go through that and give you a summary of the violations that we find and that we would be able to put into a report. We can do a forensics exam that is going to uncover violations of RESPA and TILA. It's going to look at predatory underwriting. It's going to look at predatory lending, and it's going to give you a possible rescission defense. Okay, and we're going to look at the court-ready securitization report, which we've just discussed. We're going to give you a full report with your affidavit, and we're going to.
Hold on 1 second.
Did we lose our screen?
Yeah, something happened. 1 second. Bear with me here. What's going on? Hold on, I'm going to switch presenters and then switch it back. How about now?
Yeah, perfect. It's
Okay.
back. So yeah, like we discussed, we're gonna look for breaks in the chain of title. We're gonna look for robo-signers, forged signatures. We're gonna look for issues of standing. We're gonna look for any of those violations that we see. Okay, let's continue. So it's a pretty simple solution. We've got and I've got just a huge volume of testimonials from customers that have loved what we've done, and we've helped them. The first one, Mr. Greenberg, is an attorney here that I've worked with on many an occasion. And then I've got a couple of clients that we've done reports for that have had very good results with the reports. I won't go and just read these things through, but basically what to do next is just open up your audit file, your audit tab with David at TLP, upload your basic documents, and then click and either order a free pre-screen or a full court-ready document. And there's
so this is what most people will see in their system when they're inside Loan Post, and in any client file you'll see the loan audit tab. If you haven't registered with us, you just click here to get started, and then you sign a basic agreement on how, and then that'll get it activated on our end. And then once it's activated, this is what your tab will look like. And all the client information is already filled out will transfer over to Michael Wood to look at. And you'll see, if you just want to do a free pre-screen, or if you know that you're ready to order the court-ready audit, just check off the item that you want. And then here you'll say, all right, which documents do I have? Michael, go ahead and explain some of the documents that you would require at a minimum and what you prefer to get the best results.
Okay. To get a good result on your pre-screen, the deed of trust and the note are very important, as are any assignments that you have as well. For the complete exam, we're going to look at all the forms, all the recordings, any lis pendens, notice of sale, notice of default, any assignments, any substitutions of trustee. The whole package is what we're going to need. But basically, those are the basic documents for your securitization exam.
Also, if you've already requested the QWR and received it, get that uploaded as well, because there's also some things in there that may come in handy for Michael to do his job. You don't have to have it initially. You can have it ordered, and then when it does come in, then you can upload it, and then if there's anything that needs to be added, you know, that's something that Michael Wood can be looking into to see if there's any modifications needed to the original audit file. And then here's where you would upload some of the documents and name them right here. You can upload up to 5 at a time. And then once it's uploaded, Michael will get it, give him a couple days to do his research, and then what it looks like for, let me see here. So this is what it would look like after a file's been submitted. And you can see that this is actually a free analysis that's been complete. And you can see here the note history, when everything was uploaded. And then here's the information. It looks like loan is securitized, PSA violations and chain of title issues highly likely, recommended securitization audit to order. Okay. Here's another one. Free pre-screen as well. Note is insured by FHA. Assignment in 2012 is missing. The signature page likely placed into Ginnie Mae Trust. Securitization audit is recommended. And here's another one. There is nothing in the QWR indicating loan was securitized. However, IndyMac typically did this during this time period. The presence of MERS and the loan type indicates securitization audit recommended. I think there was one where you said, I guess I don't have it here. I'll use it here. All right, here's one where the loan is not tracked at ABS net nor at MERS. It looks like a portfolio loan held by the lender. Audit not recommended. So that's the value of doing the free pre-screen. Obviously, we only allow a certain amount per client on a weekly basis. You can't just submit 20 of these at a time, and there's got to be some type of limit. Am I right, Michael? How do you feel? How long does it take you to do these free pre-screens?
Depending on how far I have to look and track these things down, they can take an hour or two apiece.
Right. So we can't obviously abuse that, but it's good to know if you're a little unsure. And then once you get the hang of it, you'll start ordering them right out of the gate for all your clients. And so this is how the system would look and feel after you start submitting them. It's very easy to use. It's all integrated in the loan post, which adds a lot of value for all the parties involved. And then as far as pricing goes, we have that in the PowerPoint. Hold on right here. All right, so the $600 cost is for the basic, and then an extra $50 gives you the whole court-ready examination. You want to explain a little bit of the difference between that, Michael?
The $600 is for the forensics exam, and that's the one that's going to cover the loan documents themselves up to from origination to funding. That deals with your Respetila violations, underwriting violations, predatory lending, predatory underwriting, that sort of thing. And the securitization is a different report. That's going to deal with the path of the note, path of the deed of trust, the issues of standing, chain of title issues, robo-signers, forged signatures, and what trust it went into. So that they're two different animals. And some people need both. Some people need one or the other. So we kind of split it up for you. Okay, and I think you can take the rest of it here, Chris. I think the securitization part is pretty well done. If has
Okay.
anybody, if I don't know if anybody done any
we had some
questions.
questions that came in. How useful is a forensic exam for loans many years after origination? Like is there any timeline that needs to be considered?
Yeah, there are. A lot of the Respatila exams, the violations have a statute of limitations on them, and you get into, depending on your jurisdiction and how friendly they are to the homeowners, some of the jurisdictions will allow you to toll from the time of discovery, and others won't. However, if we uncover predatory underwriting and predatory lending, there's for those of you who are familiar with the Dodd-Frank Act, they wrote a little section 14.3.3, I think it is, offers a set-off to foreclosure if they have violations of predatory lending and predatory underwriting. So basically, for the forensics, yeah, the timeline is important. The farther out you get from the violation, the more risky it is. But the argument can be made, and has been made, that those statutes of limitation can be told from the time of discovery rather than the time of commission. And once again, it depends case by case.
Okay. Here's a question that kind of follows right into that. Overall, what are the top violations that provide the most leverage, and why?
Easily forgery and fraud, contained in forged signatures, breaks in the chain of title. There have been cases in New York and California where federal courts have decided that if you violate those pooling and servicing agreements, the REMIC trust, because of their tax status, anything that you're trying to bring into that trust after the closing date is a void transaction. So depending on how your courts see things, having that chain of title broken in that way really takes a lot of the teeth out of the lender's standing. So that's a big one. Well, the forgeries, the fraud, the perpetration of fraud upon the county records, which essentially ends up as on the fraud upon the court at some point. So yeah, those are big ones.
All right, and then this one kind of ties into that as well. What's the first step after receiving a report that shows some level of fraud or robo-signing? Like what should be their first step? And I know it probably differs for the attorneys and non-attorneys out there, and obviously what the end strategy is if you're in litigation or if you're just trying to get the aggressive loan mod and principal reduction.
Well, yeah, and I've seen a lot of different. The first step, I think, should be to find out what's in the report, see how it can best be used for your situation. I've had attorneys take my report and submit it in a court action as an exhibit, and I've also had attorneys say, no, I get better results if I just take what's in your report, incorporate it into my complaint, and do it that way. And I've also, I've seen homeowners take the results of the report and use it in their negotiations for a loan modification. You need to decide: do you want to lead with a left hook up front, or do you want to wait and save that for the 8th or 9th round? But they're used in the very first step is to read the report, obviously, and find out what's in it, and then strategize depending on what your goal is. Do I want a modification? Am I trying to get the lender off title? Depending on what your goal is. Am I trying to, stave off a foreclosure? Depending on what your goal is how you would use it next. But having the facts and understanding the facts is going to give you, quite a bit of enhanced standing in whatever you're doing.
Okay. What about, I have another question here that's related to the foreclosure stuff, something like, what are some examples of servicers' tricks to force homeowners into foreclosure, and does the report stop a foreclosure?
Oh, those are really good questions. Some of the tricks that we've seen that servicers use, a big one that they use is they mess around with your homeowner's insurance policy, and we've seen it happen quite a few times where they will do what they call a forced placed insurance, where they will actually put a policy on the house, take your mortgage payment of $2,000, take the $1,200 of the first year's premium out of that payment and apply it to the policy just because they say they don't like the policy that you currently have, and then they short your payment, and then you're racking up fees, you're racking up late fees, penalties, and back interest, and we've seen servicers, Ocwen is one of the worst at that. We've seen them, force people into a position of having to come up with a huge sum of money to make up all these back so-called charges, or else face foreclosure. So there's things like that. Other instances where you'll have a payment that hits their office on the 10th and they don't record it and post it till the 16th, making you late, incurring late fees, and that will start that same downhill spiral rolling. So they have a lot of tricks. I read a book, a 200-page book on Ocwen and all the tricks that they use, and they can be pretty nasty.
And so, to answer the question, will it stop a foreclosure? Did you address that?
Yeah, it's having the facts will help you to stop a foreclosure. If the facts are in the report are in your favor, say that the facts prove, the report shows that the person, the party that is attempting to foreclose doesn't have standing to foreclose, yeah, you can use that to your benefit very, very well.
Okay.
Yeah, so having the facts is always a good thing when you're dealing with the bank or with a court.
Okay.
And that's what the report gives you. Yeah.
Here's one this one looks like it's coming from a non-attorney. If a non-attorney submits like a court-ready package to the bank, will it have the same effect as it would coming from an attorney? That's kind of a tricky question.
Yeah, I think that dealing with an attorney is always a good idea, but if you're dealing on your own or dealing with an advocate, still, once again, having the facts and presenting them in a manner that illustrates your point is going to get you a lot of mileage. So yeah, I would say I've seen it happen where people have used the report that aren't attorneys that get really good results.
And that's why we created TLP Advantage, is because we have the National Attorney Network that can work with some of the non-attorneys to help them, do the litigation side of things, and if they can get a client that's already ordered the securitization audit, and then fire that off to the attorney so they can do the litigation side, and there's definitely opportunity there for some of the Loan Post clients that want to learn more about that. Definitely contact us here at the Loan Post. Some other questions that are coming in: do audits work differently in different states?
That's a very good question. Most of the violations that we look for are grounded in federal laws. Depending on your state, some states are more friendly to the facts than others are, and some, depending on how you make your argument. But yeah, there are differences from state to state, and I've talked to attorneys, who tell me, well, New Jersey, forget about it. And there's differences from Northern California to Southern California. So, yeah, there are differences in how they look at things as far as state court versus federal court and state court versus state court. But in general, I would say that we're a lot farther ahead today in 2015 than we were in 2010 when I started doing this. Back then, everybody was banging their head against the wall, and the courts were listening to nothing. But since then, we've seen some very good decisions come down, and being able to present the facts has been a real boon to homeowners.
Right. Okay. I know we kind of addressed this already, but maybe we'll readdress it because I think it's a big one. And you were talking about it. You touched on it, but didn't really focus on it. Can the audit be used after a person has been foreclosed upon to get the home back, or at least receive some type of damages
That is, I've talked to attorneys around here and around the country, and there are different strategies being employed. Wrongful foreclosure is one. You have the facts that the foreclosing party either A, didn't have standing to foreclose, or B, foreclosed improperly. There's a case to be made for that. I know in different states are different as to whether they give you the house back or not. We've seen in Washington, Bank of America has had a couple of residential foreclosures overturned. And in a lot of cases, like you'll have upwards of triple damages involved rather than the property coming back. But yeah, it's and there are attorneys that are going after looking at things in terms of Consumer Protection Act and Fair Debt Collection Practices Act, and uncovering some of the facts that we do as far as violations in the foreclosure process are germane to those cases as well.
Okay. That was a good answer. So let me see. Something else is pertinent that comes up. The money side, what's this retail for clients? It's on the screen. That and depending on what state you're in, what kind of client you're dealing with, but prices range from on the low end to 800 up to 2,000. And the other question is, can I charge up front for an audit? And that's usually a gray area depending on what state you're in and what they constitute as, foreclosure rescue type services or whatnot. But I believe an audit is something tangible that they can sell and charge money for it up front as the documents delivered. Am I right?
I've seen that, and I've seen attorneys also that are using audits as part of their strategy. Everybody charges a retainer up front, and a lot of attorneys include the cost of the examination in that upfront retainer.
Okay. Another good question. How do the servicers respond to the audit if you submit the whole thing versus and does the audit usually trigger the file to move to the legal department?
That's a very good question, and I think that depends on how it's used. It's kind of like asking, well, if I slap you versus hit you, is it going to start a fight? Or if I compliment you versus insult you, is it going to start a fight? It's a good question, and that goes again to the notion that every case is individual, and every negotiation can be individual as well. What we see that has the best effect is they're going for like a modification, is to present the package to the lender, the mod package, with all the HAMP information, et cetera, and then after it gets input and registered with the bank, and as you're moving along through the negotiation, you would present facts from the exam at that point. And it's always up to the person doing the negotiating to know, when the best time for that is and how to do that. But yeah, we've seen good results with that.
Okay. All right.
Does that help answer the question?
That was a good way to answer that. And it looks like we're running out of time. There's a couple more questions, but let's go ahead and wrap this up. We'll send those answers out individually. I want to thank everyone for joining us today on the webinar. We'll send out a recording of the webinar as well to everybody. And if anybody has any questions, feel free to reach us directly. And we look forward to working with you guys and getting up and running and answering all your questions. Have a great day. Thanks a lot. Thank you very much, Michael Wood.
Thank you, Chris.
Bye, guys.